Since the time I appeared yesterday in the district court before Judge O'Shea, there was a search warrant while we were in court yesterday that was executed at a condominium that's being leased by the defendant. In that condominium, there was found, as the brief or the affidavit articulates, the defendant, in his home, there was a prior search warrant for 22 caliber ammunition. There was a 22 caliber firearm that was found a distance between the murder scene and the defendant's house. In that condominium, there was 22 caliber ammunition, similar to the ammunition recovered in his house, and also which would work for that particular gun. The murder weapon in this case is a 45 caliber firearm. That's all been matched. Casings found at the scene, 3 of which led to the body. As the victim was shot, he attempted to defend himself by putting up his arm. The first round struck him in the outside of his forearm, traveled through the inside of the forearm, and entered his body, the right abdomen. From there, he began to turn and was shot in the back 2 times. And then, after he was on the ground, the ballistic evidence would show that the defendant and Confederates advanced on him while he was down, shot him twice through the chest, in the area of both of his nipples, and those projectiles were recovered right under his body. They were 45 caliber projectiles. All of the rounds were matched to the same unknown firearm. There was a shell casing found under the driver's seat of the car that the defendant was driving from Boston. His movements were tracked from Boston all the way to where the vehicle is seen going through the industrial park that was consistent with his drive going home. It went in there at approximately 2:26 in the evening. It exited 3 minutes later. There were gunshots that were heard by people who were in the area during that time. The vehicle then exited at approximately 3 minutes later, and 2 minutes after that, the same vehicle, or vehicle consistent with that vehicle traveling the same route, heading in that same direction, arrived at the home of the defendant. Yesterday's search warrant, at a condominium being leased by the defendant, they found 3 boxes of 45 caliber ammunition. Similar, there was a mixed amount of mixed manufactured type of ammunition recovered at the scene. It wasn't all the same ammunition. That ammunition found in his condominium matched that ammunition. There was a search warrant then done. Further in that search warrant, there was a rifle, a box of rifle ammunition. The defendant has been charged with possessing a large capacity semi-automatic Hungarian rifle. That ammunition was the same caliber and would be fired from that weapon found in his home, with his fingerprint on that weapon. That ammunition as well, I believe there was a box of it that was found at the condominium. There then was a search warrant of a Hummer that was in front of the condominium, registered to this defendant, with his paperwork inside mailings that were made to him. Inside the console was a clip to a 45 caliber firearm. This defendant has no FID card, no license to carry. And in fact, since I appeared in court yesterday, there was then a photo that was shown on the internet of the defendant holding a Glock 45, which is the same type of weapon in terms of what was captured in the defendant's hand before he left his home, essentially an hour or so before the execution of Odin Lloyd. And the same firearm, same in terms of description, it appears to be a Glock. It's a semi-automatic, seen in his hand when he returned. And that Glock, there's good reason to believe that the firearm that killed Mr. Lloyd was a Glock, because Glock has a rifling system that's different than most firearms. And it's a polygonal rifling, which is the manner in which the bullet, when discharged, moves through the barrel and cuts into certain grooves into the side of the projectile. The bullets that were recovered, 2 of which were recovered from the body of Odin Lloyd, 2 recovered from just underneath his body, are consistent with polygonal riflings, consistent with being fired by Glock. It's unusual in the sense that other firearms do not possess such rifling. So in terms of the case brought against the defendant, I'm going to respectfully suggest to the court the evidence of his guilt is overwhelming. And I do object to relying on the opinion by Justice Cowan, whether he even has a right to appear before Your Honor. But he is a flight risk. He has the means and the motivation to flee the jurisdiction. In the course of the case, the investigation revealed that he's interfered with the movement of the investigation. At one point, when police were interviewing a girlfriend, he called and told her to stop talking to them. There was surveillance footage that was recovered from his house immediately after the crime. That surveillance was then destroyed. He also, as to his Confederates, within hours later in the day, he went to a rental agency and then got a new car for his two Confederates, and they then fled the jurisdiction. So there's every reason to think that, one, he will be convicted of the offense, that the case against him is strong, that he would then be looking at a sentence of life without any chance of parole. Two, that he would flee the Commonwealth and potentially flee the country. He has the means to do that and the motivation to do it. And three, that he would engage in conduct that is already consistent with how he's behaved so far since the investigation began. So most respectfully, Your Honor, I'm going to ask that the order of the district court not permitting the defendant any bail be honored, and that the court hold him without bail until his next court date.
I'll respond very briefly, Your Honor.
I just have a couple questions for Mr. McCauley, and then give me whatever time you need. With respect to the motive behind what you described as an execution, could you just detail what the Commonwealth's evidence is with respect to the motive?
Your Honor, the motivation, and there is, I addressed one part of it as to the sidebar as to additional information that I would not be prepared to disclose at this time. But as to the part, the motivation for this defendant to kill the victim. On Friday, they're known to each other. The parties are known to each other. The victim had begun to date a young woman about a year ago. That young woman's sister has been in a long-term relationship with the defendant. They share a child together. They live together. Their relationship was generally, when they would get together, it was at family events. And over time, Mr. Lloyd became friendlier with the defendant, and on Friday night they had gone out to a club in Boston. At that club, apparently Mr. Lloyd saw some people that he knew and he began conversing with them. The evidence would suggest that the defendant took exception to that. And later, again in the hours before his death, he made the arrangement to call Mr. Lloyd acquaintances from out of state, and he was texting them and requesting that they come to his house. There was a series of texts that followed where it was more urgent. You know, where are you? Get your ass up here. And then another one even later. Hurry your ass up, or something of that nature. Those individuals then arrived. The video shows the three of them getting into a silver Nissan Altima and leaving the home of the defendant. Before he left the home, he's observed with the .45 and makes a statement about that he can no longer trust anybody. They then get into the car. They then travel, and it's documented his line of travel and route of travel in terms of time and distance, cell phone records, tower records, as well as surveillance footage that's captured. The victim is at his home at about approximately 2:32 in the morning. He gets a text from an individual who's in the car with the defendant. At that time, he leaves the car, he leaves his home, and his sister is present. She sees him getting into the car, the silver Nissan Altima. That's also captured by surveillance in the neighborhood. He then begins the drive back towards North Attleboro. There was a conversation that occurred in the car where he gets into an argument with the victim. And he's saying to the victim he's unhappy about him talking to those individuals, and that he can't trust him anymore. He indicates that he's had a problem with the individuals that he was talking to, and that's why he's upset. During the course of that ride to North Attleboro, the victim begins to send text messages to his sister saying, "You saw who I left with." There's evidence in the case that he was now concerned for his own safety, because he then followed that up when she didn't respond because she had lost the charge in her phone. Literally minutes, and this is consistent with surveillance footage. That car coming down was described as John Deach Boulevard. As it came through the industrial park, at the same time it was beginning to head down this gravel road that this defendant would have known because it's right as he travels his route. These other individuals were from out of state. They begin that. He texts a message and says that this is NFL. He refers to him as NFL because she responds back and she said, "Who?" He says, "NFL." And that's at 3:22 in the morning. And then at 3:33 in the morning, he said, "I just want you to know." Literally 2 minutes later, shots are heard. At 3:25 in the morning, shots are heard by folks who are working the midnight shift in nearby businesses. And then within a minute or two, this vehicle is observed coming out and going toward the home of the defendant. 2 minutes later, at the home of the defendant, car pulls up, 3 individuals get out, 2 of whom have firearms, 1 of which is the defendant. Again, that same was consistent with a Glock 45 firearm. So as I indicated, Your Honor, that the evidence in the case is overwhelming in terms of his motivation. He had a motive. In fact, he was the only person who had a relationship with this individual. There was no evidence of a robbery. In terms of the location of the scene, he was the one who had the knowledge of the scene, the area. It was approximately, I believe it was less than half a mile from his home. He was the one who was in control the whole time, from the pickup to the drive to the site, to his home, of the vehicle. He had the motivation. He was the one who was angry with him. He is also the individual who's then engaged in the conduct that followed to essentially thwart the investigation of this matter. So, respectfully, I would see there would be no reason to permit the defendant to any bail based on the strength of the case, his motivation, his opportunity, the means. The means, he literally had the gun as he got out of the car. And then all the other evidence, there were search warrants done to the home, these other weapons that further ensnare him in his acts. And now, additionally, the evidence of this photograph where he's holding a Glock 45. When they do the search of the home, the same 45, strike that the same firearm that he's holding is not recovered. And the other gun that was observed in the hands of the other party, that's not recovered either. So that gun then moved right after that. The vehicle, there's damage to the vehicle in terms of a broken mirror on the side of it. That mirror has not been located, but that search continues. It's an ongoing investigation. There's other matters that we were dealing with. But again, Your Honor, I'd ask that the defendant's request be denied.
Thank you. Mr. Secretary.
Well, there are very good reasons why we don't try cases at bail hearings, and I think that the court has just been witness to it. They have their theory. We look forward to testing the quality of their evidence at trial. We're not talking about undated internet photographs, and that's the level we're talking about. So we have a long way to go in this case, Your Honor, but I submit